Welcome and thank you for joining Seyfarth's webinar, Employee Mobility and its Effects on Trade Secrets and Non-Competes. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Justin Bayer. Justin, you may begin.
Good morning. Thanks, Sadie. As Sadie mentioned, this is our third installment of the Seyfarth Shaw Trade Secret webinar series. Today, we'll be focusing on employee mobility and its effects on trade secrets and non-competes. Can you please go to the next slide? As you would have seen when you signed up for this, please understand that this is a general presentation only and should not be construed as legal advice. If you do have a situation that is similar at all in any respect to what we're discussing today, please consult with an attorney, hopefully a Seyfarth attorney, before you consider any of this to be legal advice. Next slide, please. As Sadie mentioned, my name is Justin Bayer. I'm a partner in our Chicago office for Seyfarth Shaw. My practice focuses mainly on trade secret and non-compete matters. Joining me this morning or afternoon, wherever you're joining from, is Ian Long. He's a senior associate in our San Francisco office. Ian mainly focuses on labor and employment matters, but has a fair amount of his practice, which is trade secret and non-compete matters as well. Next slide, please. As all of you have experienced over the last several years, we are living in a new normal. We have employee workforces that can be primarily remote or at least partially remote. We have new technologies that have emerged and have disrupted the spaces in which we all work. For example, 2 years ago, this webinar would have been produced by telephone. You'd see the slides in the deck, but you'd see neither Ian nor I on the screen, and so we wouldn't have to be quite as dressed up as we are right now. It's fair to say that what our workforces look like now are becoming more global in nature, more national in nature. We may have employees in states where we don't have a physical space. We may have employees in a country where they're the only employee. And so with remote work, employee workforces need to be considered in a new and different way. And unfortunately, because of that, it also puts at risk trade secrets and how those need to be considered in the workforce. Next slide, please. While we're going to cover a fair amount of material today, it's also fair to say that there's a breadth of material out there, whether it be from Seyfarth Shaw or another law firm. Lots of different places are focusing on this information. You can find a host of information on our website, the Seyfarth Shaw TradeSecretsLaw.com blog. We also have a wealth of information related to COVID and how that's impacted employers as well, which can be found at Seyfarth.com/COVID-19 Resource Center. While some of that is changing right now, who knows what the next month could look like. Next slide, please. What is our agenda today? Well, first, we're going to focus on trade secrets and restrictive covenants generally. So to give some background there from a legal context. We'll then move on to talking about practical tips for onboarding employees, what it looks like during employment and outgoing employees. I'll handle the first section entirely, as well as the inboarding, and then Ian is going to focus on during employment and the outgoing employees, as well as our third section, where is the law headed in these areas. Next slide, please. So first off, we're going to talk about what a trade secret is. Trade secret is defined as information generally not known to others that has economic value that is subject to reasonable efforts to maintain security. So what all does that mean exactly? Well, this is a legal definition, and this is something that is going to be defined generally on a statewide basis through the Uniform Trade Secrets Act, which has been adopted in every state in the country with the exception of New York. or possibly through the Defend Trade Secrets Act, which is a federal statute. Next slide, please. Focusing in on the actual trade secret, it's a host of different, it can be a host of different types of information, but it needs to be something that is generally considered to be secret and provides independent economic value to the company. And that is obviously subject to reasonable protections under the circumstances. So what does that mean exactly? Well, the classic example would be, what exactly is the formula of your particular business? That could be your customer relationships. That could literally be your manufacturing process. That might be the secret formula to Coke. There is a host of different things that can constitute a trade secret from a definitional standpoint, but then the main focus is, does it provide value to your company, and is it subject to reasonable means of protection? Next slide, please. We talked about customer lists for a moment ago. It can include source code as well. Part of the value has to be considered independent of it being secret. So what exactly does that mean? Well, let's talk about a customer list for a moment. Customer lists are something that often are fought about in a trade secret litigation. And some of the classic examples back in the day would be a literal list of customers. They're not known outside the industry. That has morphed a bit. Now it can be customer preferences. What does that constitute? Is that actually secret? Is that actually something that is subject to efforts that you have taken through the years to collect that information that may not be in the hands of other people? It could be public information, but maybe you have consolidated it in a way that is unknown outside of the industry. So those are some of the information, some of the things that can constitute trade secret information. Next slide, please. I mentioned a moment ago the Defend Trade Secrets Act, and it's getting a little bit older now. It's something that was instituted in May of 2016. In many respects, it is very similar to the state laws regarding trade secret information, but there are some notable exceptions. One, it provides federal question so that it's something that, irrespective of whether diversity exists or another federal question exists, something can be brought before the federal court in your state. Why is that important? It can depend. Sometimes there's strategic questions there. Sometimes the federal courts are slightly better equipped to handle that type of information. Sometimes you may just prefer the judge pool that exists there, but it does offer opportunities for consideration. But there are some things that are important to note about that. For example, while the Defend Trade Secret Act provides for enhanced damages as well as the opportunity to collect attorney's fees if you're successful and some other things are proven, if you're relying on an agreement that postdates May of 2016, you have to notify the employee of certain safe harbor language that exists in the Defend Trade Secret Act. And what that essentially entails is that while the Defend Trade Secret Act prohibits misappropriation of trade secret, it does provide the employee with a limited number of opportunities to disclose trade secrets without potential harm to them. One of those would be in a whistleblower context. Another of those would be to an attorney or the government. Again, it doesn't necessarily have to be whistleblower. That is the overarching language that is suggested, but there's not a lot of doctrinal information available on that. So it may develop through the years, but at this point in time, those are the safe harbor options. And in order to get those enhanced damages or the opportunity to collect attorney's fees, you have to inform the employee of that. It also prohibits employers from, under the Defend Trade Secret Act, seeking what's referred to as inevitable disclosure injunction, which would effectively allow the court to enjoin someone from working for a competitor if there is a threat that they will inevitably disclose the trade secret information. That may still exist under state law. There is obviously some tension between state law and federal law on that, and there doesn't seem to be a ton of case law suggesting that you're not able to obtain the inevitable disclosure injunction, where you've also sought the Defend Trade Secrets Act injunction, or Defend Trade Secret Act claim. It's just, you may be bringing a state law claim and a federal claim. Next slide, please. So we talked a moment ago about what you must do to protect a trade secret. And put simply, you can't disclose it publicly. There are a slew of cases out there where someone has claimed a trade secret only to have, the other side say, you publish this information that you're claiming in a trade secret in a customer, a customer deck that you publish on your website. This was information that was contained in a public paper that was presented by someone else entirely. So at its core, a trade secret must be kept secret. Next slide, please. So what does it actually require, though? Well, that's going to depend a large extent on what the court deems to be reasonable under the circumstances. It's important to note that absolute secrecy and every effort under the sun is not required. It's only reasonable. What may be reasonable for a single city mom and pop type shop with under 50 employees may not be, and probably isn't going to be, reasonable under the circumstances for a Fortune 100 company. It's just going to depend. I would say that probably your best way of demonstrating that you have reasonable circumstances you have reasonable security under the circumstances is having prevention protocols. What does that exactly mean? Well, for example, do you have a confidentiality program? Do you require employees to sign documents at the outset of employment that require them to maintain the confidentiality of the information, both before and after employment? Do you have onboarding and offboarding measures to protect your confidential information? Do you have certain security protocols in place? And almost every employer these days are using the internet in some fashion or other, or providing email access to employees in some fashion or another. Are you taking what would be deemed to be reasonable measures to protect that information through that? And so by creating protocols, which if you don't have, Seyfarth Shaw is a wonderful resource to utilize to help create those with you, then that'll get you a step closer toward demonstrating, or being in a position to demonstrate that you're taking reasonable measures. The other thing that is important to note is what happens in the situation where, let's say you have a disgruntled employee who leaves and either takes the information with them, utilizes it on behalf of themselves or a competitor, or happens to post it online. Well, part of those reasonable security measures are taking active steps to recover that information, to take down the information if it was posted. Again, what does that mean? What does it mean to be reasonable? It just may depend. And so, it's important if you're in that type of situation to be really mindful about it and just not ignore it. It's not a problem that if you ignore, it's just going to go away, because once that box is opened, the cat is out. I mean, the cat is out of the bag. I'm kind of mixing metaphors here, but the point is the same, that you need to be mindful about your approach to protecting that information. Next slide, please. So we talked a bit about your protocols in place, and I also referenced this in the Defend Trade Secret Act section, but restrictive covenants are a tool that are utilized to protect or to demonstrate protection of your confidential information. And what does a restrictive covenant look like? It can have a host of different provisions. Some have all of the provisions identified in this particular slide. Some have, are a little piecemeal. The important point is that your program related to restrictive covenants should not be a one-size-fits-all necessarily. It should be mindful of what your business interests are and how you sufficiently need to protect those business interests. For example, do you need a non-compete program for every employee in your company? Do you need a non-solicitation provision for every employee in your company? Do you need a confidentiality provision for every employee in your company? The answer to that question may differ depending on what your business is. But this program is in part geared toward helping you understand those considerations. Next slide, please. The other thing that is important to note about your restrictive covenant program, to the extent you're utilizing one, is that you need to be mindful that the law around the country is ever evolving. In particular, we've seen over the last 10 years a host of state statutes that have been enacted that have either curtailed the use of certain types of restrictive covenants entirely, or placed a host of restrictions on them. For example, California, effectively has a ban on non-compete agreements and non-solicitation clauses through statute and through case law. But within the last several years, one of the carve-outs had been whether or not employee non-solicitation provisions were effective. An employee non-solicitation provision is one where the company prohibits the employee from going to a competitor and attempting to solicit other employees of the company to come over. There's a series of cases that have started to come out over the last 3 to 4 years that severely calls that into question. Illinois, another example, they just enacted a statute effective as of January 1 this year, which places further restrictions on non-compete agreements, non-solicitation agreements, putting a monetary threshold on where those are appropriate. So that's something that companies that have Illinois employees need to consider. And this is true for states throughout the country, and as I mentioned, it's ever evolving, so it's important to keep abreast of that. Next slide, please. So with that background, let's move into talking about your best practices for incoming employees. Next slide, please. So truly, the employee life cycle is effectively your onboarding, your recruiting and onboarding, your employment period, and then it starts again when that employee leaves the company. It probably should say offboarding in that last little bit of the life cycle, but the point remains. This is a cycle as it relates to every employee. Next slide, please. It's important to note that there, again, really is no one-size-fits-all approach for this. It really comes down to a bit of a balancing act. And what I mean by that is you have to balance the fact that well, let me back up for a second. We're operating from the assumption that you are hiring or you're considering for hire someone who would be considered a competitive hire. So you're Coke, you're hiring someone from Pepsi. That's our scenario here. And so what ends up happening is you have to strike a very important balance between knowing too much about what this person is doing and not knowing enough. And what is that appropriate balance? Well, one of the places that I would suggest is that you always ask for a copy of any employment agreements that they have. Or if for whatever reason they have confidentiality provisions about the terms of that agreement in the agreement, at least the context of the restrictive covenant. You have to know enough about what they are doing to determine, A, can I make this hire? And B, if I do decide that I want to make an offer of employment, can we put them into a position where we're not putting at risk the trade secrets or confidential information or other legitimate business interests of the competitor? You are not only risking a lawsuit against the new employee, but you're also risking a lawsuit against yourself if you've not taken steps necessary to avoid a risk of a claim of tortious interference with their contract or possibly trade secret misappropriation by not taking steps yourself. The other thing that you have to do is generally you want to set clear expectations in the course of this in this conversation. So what does that mean exactly? Next slide, please. You have to evaluate each of these types of situations. Okay, so is their former employer a competitor? Is their former employer possibly part of a larger conglomerate? For example, maybe they're not individually a competitor, but do you know their employment history well enough to know, have they bounced around between different, different subsidiaries within the same family of companies? If, for example, 6 months ago, they were holding a completely different position that was maybe, like, say, research and development with someone who actually is a competitor, and 6 months later, they're with a different part of that same conglomerate of companies, are you putting yourself at risk for claims that you're utilizing information that they acquired that isn't stale at this point? And so these are some of the things that you have to consider from the outset. Are they a competitor? What role are you considering them for? There are lots of times where agreements are structured in such a way that they prohibit a departing employee from operating in the same territory they were in, from holding the same or substantially the same position. Sometimes those agreements can be written more broadly, though. They can't compete against compete against their former employer with any of the customers that are the customers of that former employer. And so part of what your analysis has to include is, do we think this agreement is enforceable? Is there a position that we can put them in that they're not going to be a threat to that other company, or not perceived as a threat? Because there's never a scenario under which you can completely eliminate the risk of a lawsuit. The best that you can really do under those circumstances are either to minimize your potential liability and create a record where, if you are engaged in some sort of letter writing campaign, you can say, we took these things into consideration, we put them in a different role, they have no responsibility for their former customers. And those are things you can articulate that either you can help to alleviate some of the concern of the former employer, but also it mitigates your potential risk along the way. Next slide, please. So as we consider this as well, you have to also, again, and this is going back to the minimizing risk piece of things, is you have to take into consideration how much do you want to be involved with this employee's departure from the competitor. So I would always recommend that they ask for a copy of the agreement. Sometimes we may recommend that the hiring employer get some sort of language from the departing employee from their former employer that says they're not going to enforce a non-compete under these circumstances, or that's going to be a waiver language. But on the other hand, you don't want to be stepping into the role of acting as their attorney. So some of the advice should be, very, very above board, and you would want to say in your offer letter, for example, we are not interested in any information that you may have from a former employer. You should not bring any of that, and if you do bring any of that or use any of that, that would be grounds for termination. And so you're making the information known right away that we don't want this. But on the other hand, you don't want to necessarily have your people poking around in their computer making sure that anything is deleted. So there's this fine balancing act. And so I am now going to, we're going to now transition to after the point that you've made the offer, they've accepted employment, and Ian's going to cover best practices during the employee's tenure.
Yeah, so as Justin said, let's say you've gone through the risk assessment and you've decided we're going to take this employee on. One of the first touch points for that employee is going to be their onboarding process. First, we'll kind of talk a little bit about, kind of policies in general to give that employee during part of that process. So as Justin mentioned, I would love to be able to tell you, every employee coming into your organization should get, this type of agreement and have this type of restrictive covenant, et cetera. But there is really no one size fits all approach for organizations. What documents that you have the employee sign will depend on what the business interests of your company are, where kind of the key value of your company is located, what you want to protect, et cetera. And remember too that not all employees might need every type of restrictive covenant, as Justin mentioned. Now, of course, many of you run very complicated, very large organizations, and it might be very difficult to try to tailor as much as we, as outside attorneys, would love you to. It's always a balancing act, right? Between your HR department, making sure that you can actually implement, giving the correct packages out to every new employee and not making it too complicated on that front. But on the other hand, trying not to overreach and invite, lawsuits or challenges based on having too broad and too restrictive a set of policies. Another big issue is what state law is going to apply. Does that state restrict your options? And so I would suggest that, for example, if you have an organization that has, some key job classifications that take up, a majority of your workers, and that's kind of where the value of the business might be located, and a restrictive covenant is important in that space. Maybe you could have HR roll out a specific set of agreements to that job classification. If you just have maybe 2 or 3 big buckets, that could be something that you might be able to roll out, and it wouldn't be too difficult for the HR team to implement. Others, larger, more distributed organizations that have a lot of different job classifications, it's more difficult to kind of strike that balance. I will also say here that while we as attorneys, love our policies, what is very key during the onboarding process is to make sure that managers are ones that are addressing and implementing these expectations for your employees. So just as a manager would sit down in onboarding and say, our expectations are you arrive at a certain time. We, expect a certain style of communication. Here's how your performance evaluation is going to happen. Should also encourage managers to have, as part of that conversation, these are expectations around confidentiality, around keeping certain types of information, within our organization. And that can be conversations such as a manager for a software developer saying, look, this is where we store our code, this is where we do our work. These are our expectations that you won't move that code outside into your own repository to work on it and move it back. For salespeople, talking about, we expect that all communications will go through our email system, not yours. Those are conversations. While we all love policies, we all know that, employees might not read them as much as we would like them to. And it's important to leverage managers and HR to have those kind of personal conversations to set the tone and the culture. Next slide, please. So in the context of remote work, and as Justin talked about, the kind of changing and ever expanding kind of reach of workforces, part of the process to make sure that your data is protected is to make sure that you've got policies that have reflected this change in remote work. So I think of the pandemic as kind of first 6 months, we're all freaking out, figuring out how is this going to work. The next year and a half was trying to figure out, okay, starting to get a hold on it, trying different remote styles. And at this point, I think many organizations have kind of settled in on what you're going to try to implement going forward. And it's important at this stage to kind of formalize that the policies around that situation that you've kind of implemented. So key among these, obligation to update the location of the employee, right? You want to know where your employees are so that you can know what types of agreements might be in or out of bounds with that. With remote work, there's also, more opportunity for technological monitoring. Privacy policies should be updated for that issue. Email and cloud accounts, your organization might have moved to different, more distributed kinds of technology. Policy should implement that. And as Justin said, Seyfarth has a great team that can help kind of update policies to reflect this kind of new reality. Okay, next slide. So along with onboarding in that first touch, key to continuing to protect your assets and keep them confidential is training. And that can be both formal and informal. We're trying to get the employee to understand what is confidential information, what is important to your organization, what does the policy require. And I'll note here again, there can be the formal aspect of it, maybe yearly or every 2-year trainings, but again, managers and your HR team and the kind of constant touch with your employees is really your first line of defense to protect your trade secrets. I think about as a younger attorney, I learned a lot about these issues by being with partners at trial and noticing that when they put confidential documents, in the car to drive home, they put them in the trunk so that if they park somewhere, there wouldn't be any type of, there'd be less of a threat. How did you talk about confidential information in public? Certain, topics were not, addressed in crowded rooms. These are all things that I learned in person, and in the remote context, it can be more difficult, especially with younger employees, to try to implement those norms that can be so important to protecting, information for your company. And so encouraging managers to touch base with the employees, to explicitly have those conversations, especially when remote, is important because a lot of the cues that we would get in person are not necessarily there in the remote context. All right, next slide. So I mentioned monitoring of employees earlier, and in general, technological monitoring has become more important in the remote context. That can take a variety. You can implement a lot of different versions of monitoring. Costs are different, and Seyfarth can kind of help you, if that's something you want to explore, look into potential options. Next slide. But along with trying to technologically figure out, what are your employees doing, where is data being transferred, etc., also having a technical infrastructure that kind of helps them make the right choice is also important. So things like requiring password protection regularly, requiring two-factor authentication, prohibiting them from downloading certain apps that might cause security concerns. All of those issues, are important in a more remote context. So it's not only trust, but verify the employee and try to help them make the right decisions. Next slide. But again, can't emphasize this enough. First line of, while we love to rely on technology, monitoring is also your first line of defense. Your first, eyes and ears are your managers and your fellow employees. Technology can be cost prohibitive, but Managers are the first ones who will be able to see, hey, I'm starting to get a lot of emails attaching important documents from my employee's Gmail account. Last time I was on the phone with this employee, they were in a very crowded room and we were talking about a sensitive subject. Managers need to be trained to make sure that when those types of issues come up, that they can use that as a teaching moment and talk to the employee to make sure that some of the employee's actions might be outside of your organization's expectations around privacy. And as part of that, managers themselves need to be trained, understand what the scope of the restrictions are. And so before we move on to departing employees, I think the key takeaways for your current employees is, technology is great in a remote context, policies are great, but that it's best to combine that with good management. All right, next slide. So departing employees. When you find out that an employee is departing, especially in the remote context, there are a number of things to consider: assessing risk, collecting devices, an exit view, a time frame. Many of these issues are harder to institute in a remote setting, but it's still worthwhile and necessary to pursue them to make sure that the proper procedures are being followed to protect your company's assets and information. So next slide. Similar to talking about, assessing risk on the front end, where is the employee coming from in an onboarding context? Find out that an employee is departing, need to assess risk to figure out, just how much effort, time, potential cost should be put into making sure and managing the departure. So was the employee in a senior or strategy role? Did they have sensitive position? You getting senses that the departure was sudden or involuntary? What employer are they going to? If you find that out during the exit interview, all of these are things that will help kind of craft what the departure management process will look like. Next slide. So before the employees either terminated or departed, you need to have a plan. How are you going to get your assets back when that employee is leaving? So again, this is more difficult in the remote context. Asset tracking is key. What devices are they using? Were they also using their personal phone along with the company phone? Were they using personal email? Did they have two computers, maybe one in the office, one at home? Also, all of that needs to be taken into account, and timing of the asset recovery matters. The earlier, the better to get those computers, hard drives, phones, whatever it is, back. The classic problem is the post-terminated employee laptop problem. Don't get that laptop pretty quickly after the termination. It gets harder and harder. The employee may become less and less responsive, gets more and more complicated. You might not have the ways to communicate with them if they move, etc. Trying to get that laptop back becomes a much more costly and bigger headache. Seyfarth has remote data assessment tools like Seyfarth Scout to kind of figure out, where everything is that you might need to recollect. Exit interview and logs can also help. But again, when possible, talk to the manager, talk to fellow employees to the extent you can, when some terminations are sensitive, but to the extent you can, to try to figure out, what are we going to need to do to make sure we protect these assets. Next slide. Now, I mentioned that kind of before the exit interview, because the exit interview, to the extent you get one with the employee, is probably your best shot to try to deal with as many of these issues in one fell swoop as possible. Recovering data is a key part of this, and also reminding the employee of their obligations and their expectations going forward, including surrounding trade secrets and restrictive covenants. So to help HR out with that, some organizations have a script to make sure that a lot of the key issues are covered. But whether you got a script or not, training up HR to do the following is really important. Remind the employee of their obligations, get those documents and property back, make sure they have copies of their agreement so that they really understand what the terms are. To the extent you can, find out the employee's plans, where are they going, so that you can monitor the situation going forward. Again, exit interviews, sometimes harder with remote, right? But it is still necessary to do them. And for future litigation, as I mentioned, the checklist, making sure that the HR or whoever the contact is for that exit interview, make sure that there is, to the extent you can, get some type of record about what was covered, what the expectations were communicated, and things like that, so that the employee on the back end can't say, oh, well, I didn't know, or, oh, I never thought that this piece of information was important or protected, and that's why I walked out the door with it. You want to avoid them being able to say that on the back end. So next slide. Sometimes, the departure is not amicable. Sometimes there will be a termination, and how to handle terminations obviously have their own set of considerations in the remote context. A lot of you have probably dealt with many of these before, but this slide kind of talks through some of the difficulties or the challenges in a remote context. Next slide. And these are some of the searches that you can do, assuming that the employee might find that you have some type of sense that there's a risk here, that you might want to pay a little bit more attention to managing this employee's departure. Here are some of the searches to do pre-termination. This can kind of help inform what attitude you're going to have to the departure and what to do in the management of the departure going forward. Some organizations might choose to do all these searches for every employee. Others organizations might choose to do them only for ones that have been identified as high risk. But these are some technologically assisted remote management tools that can help determine kind of the scope of what the employee might have. Next slide. All right, and so again, it will change depending on each organization, but make sure that the devices are returned. How you choose to do that in a remote context, can change organization to organization, whether it's FedEx box, whether it's with tracking, whether it's courier, whether it's come in on your last day. That will all depend. Potential next steps, depending on the level of risk, could be a reminder letter to employee about their obligations, could involve a letter to the new employer, and kind of the kind of nuclear option is a lawsuit and a TRO, but that's kind of outside the scope of this presentation. But I will just say, kind of, next slide. These are just kind of some of the ways that employees can try to, circumvent some of your protections. So before we move on to where's the law, I'd say probably a key takeaway is it's best to have a set of procedures that will be followed with either every employee or every employee of a certain level, and making sure that, whatever your procedures are, fairly regimented, and there's documentation that they have been implemented as far as going through and making sure you collect laptops, making sure the employee has been reminded of their obligations. To the extent you want to go beyond that, it might be a employee by employee risk management, but to the extent you can kind of formalize these procedures, make it a regular process for your HR team and document it, that is best practice. So where is the law going in this context? Next slide. We've talked about, kind of the variations in states. When Biden was elected, there was some talk about, how much, especially in the restrictive covenant context, and a swirling conversation about, do restrictive covenants harm workers? What's Biden going to do? While we've seen an executive order that kind of encouraged the FTC to consider rulemaking around this, and a workshop that similarly, it dealt with a very wide range of topics. And while there were some negative conversations towards non-compete, there were also some speakers who kind of pushed back on that and said, well, it's not that simple, that restrictive covenants can have benefits for organizations and employees. The workshop really didn't come up with any commitment towards particular rulemaking. And so while there has been talk kind of in the federal context, we currently don't see anything that indicates that there is rulemaking going to be coming out, right away in this context. So that leaves it largely still to the states. Next slide. So we'll talk. It's kind of impossible to talk about all of the state changes that are coming through the pipeline. But we'll cover just a couple general trends maybe to keep a lookout. And one of the key trends is the movement kind of from common law to a more legislative or regulatory kind of posture towards especially non-competes and restricted covenants. So, whereas the common law used to be pretty slow in developing, now legislatures are getting involved, and that means that they're all coming up with their own rules. We've seen just a huge explosion of those in the past decade or so. One overall trend is kind of low wage bans that prohibit certain types of restrictive covenants below a certain wage threshold. Every state is different. We already had 10 states implement it. 3 might be coming through in the next year or two. But this is kind of a position that might have more popularity because it kind of strikes the balance between the argument that low wage ban restrictive covenants hurt employee mobility, especially those who don't have access to certain types of information, which some people make that argument, and the understanding too that that might not be fair to businesses, especially in the context of high executives and others who are getting paid well because they do have access to all of this information, and that maybe the equity does encourage kind of upholding restrictive covenants in those contexts. Low wage bans are kind of a way to reconcile those two conflicting kind of criticisms. Okay, next slide. Your governments are getting more, how should I say, active or aggressive. Colorado, recently said it's a misdemeanor to enforce an otherwise unenforceable restrictive covenants. It's a fairly vague statute. It's unlawful to use force, threats, or other means of intimidation to prevent any person from engaging in any lawful occupation. So does that involve simply asking an employee to sign a prohibited non-compete? Is that definitely criminal? About threatening to enforce the non-compete, is that criminal? Puts puts organizations in a tough spot. DOJ antitrust has also become more active in kind of the no poach space. They've brought several indictments. One that most recently go to trial, the first kind of no poach go to trial, was actually an acquittal, however, of a healthcare organization, a nationwide healthcare organization, and they were actually acquitted at trial involving this no poach. But I would not hold my breath to wait to see the DOJ kind of back off their position here based on that. We haven't seen any evidence of that. So next slide. So again, kind of running through these so we have time for questions. There's just a lot kind of coming through on the states. One thing to keep an eye on is Washington, D.C. Formerly, California was kind of considered the most restrictive jurisdiction, especially on non-competes and restrictive covenants. Can't do anything in California. Well, DC is trying to give California a run for its money. The bill that has been passed, however, has been delayed at least once and now isn't set to go into effect until October 1st, 2022. So we'll be keeping an eye on that. But other pretty major states are also looking to either have or looking to change their laws surrounding restrictive covenants. And here are two examples, Minnesota and New Jersey. Next slide. Just key takeaways to remember. Vigorously protect your confidential and trade secret information. It's more difficult to do remotely, but that means that it can be even more important because the new employee mobility can provide new avenues and potentially greater risk. So, we need to implement ways to fight that risk. Confirm and adopt policies that empower you to act in the remote context. And, as far as laws are coming in, stay abreast of those. And, to the extent, certain states where you have a large workforce, they might change their law, consider should you change your policies? And that is going to be a business to business decision. And Seyfarth attorneys are always here to help you navigate some of those considerations. So with that, Justin, do you have anything to add before questions?
No, let's just give an opportunity to give the CLE code and we'll address some of the questions that came in.
Yeah. So the CLE code for everyone is SS4634. Again, that is SS, as in Seyfarth Shaw, 4634.
So we had a number of questions come in during the course of the presentation. A few of those relate to exit interviews. And I would say that the best way to generalize the questions around the exit interviews are, what are the best methods to record, whether that be in writing or otherwise, what you learned during the exit interview. So the short answer is, for example, if you are unable to get an exit interview because the employee resists or is unwilling, there are things you can do. You can always have a sort of a declaration that they're required to sign. It could be in a Word document where you say, identify who your new employer is, identify all devices provided to you by the company, identify your manager, identify, whether you have downloaded or printed any information in the last, week, why. So there's a script that you could utilize and they could fill it in. It could be as simple as like you prepared the declaration that says, I returned all of my devices. I have not taken information with me. I am aware that I signed an agreement and that, that agreement includes these provisions, and then they sign it and they give it to you. And then if they breach, then you have that as evidence. Another question that came in on the exit interview front related to whether you can record that exit interview. And that's a trickier answer to that question because there is no overarching statute around the United States that deals with recording someone either, without their permission. There are a number of states that are one-party consent states, and that one party consenting to the recording can be the party that's actually recording the conversation. So it just depends on that. But then there becomes a secondary question of really, is that a best practice for you as an organization? So there may be ways that you decide we're going to record this. You inform the employee we're going to record this exit interview. You can let them know they're in a one-party consent state and that, they don't have an option in this. But again, it just kind of depends. I mean, at the end of the day, a lot of the decisions that might be legally appropriate, you have to ask the question, does it make sense from a business perspective? Does it make sense from a culture perspective? And so going from there, you have to make those decisions. Another question that came in was a question relating to customer lists and what exactly constitutes a customer list. Does it have to be physical? The short answer is to that is no. It does not need to be a physical list. It can be electronic. That's true for any trade secret. And in fact, I would suggest that probably the vast majority of information that relates to trade secrets is going to be in some sort of electric format. So it does not need to be physical. And then it looks like we have one last question, and it's relating to whether restrictive covenants around senior leadership can require an extended period of notification. And Ian, you being a California attorney, I'd be curious to hear what your thoughts are on that. I have some of my own thoughts as well.
I think the specifics would probably matter as far as, what is going to be the potential for, lack of a better word, the punishment for leaving after 6 months. There are obviously compensation and other issues that surround that question that I think the specifics would matter. Justin?
So my thoughts is that there is no specific ban, but part of the issue is going to be how do you enforce that? You're effectively suggesting almost like a garden leave provision where you're going to pay them for extended period of time. If part of that notice period is identifying who their new employer is going to be, you may decide, I don't want them to continue to have access to information over the full 6 months, or whatever that extended period of time is, because providing them continued access to information may be opening a can of worms down the road of whether or not you adequately protected your trade secrets. The short answer to the question is that I don't think there's a specific ban. I'm not positive the best way that you would enforce that going forward, though. Would have to be one of those things that would be subject to further communication. And with that, I think we're at just about the top of the hour. Ian, I think there's a couple more slides maybe you want to run through real quickly.
Sure, we would appreciate if you take our flash survey. It is right here. Next slide. And again, mentioned a couple times during the presentation, but Seyfarth attorneys are always here, and we have a number of publications and other things that can help you get the basics. One great reference is a 50-state desktop reference. We have a blog that keeps up on a lot of the changes to state law and other changes to law in this area. So, to the extent you would like copies of these, feel free to reach out to either one of us. and we can get you some of our publications. And there is how you reach out.
Thank you for joining us.
Thank you.